And action. Hello and welcome to another edition of Car Brief. I'm Richard Auslager. I'm your host, the only host here because I don't see anybody else around. I'm a lawyer in Chicago and I handle a variety of types of cases, personal injury primarily, with a focus on automotive related accidents and automotive cases, and also criminal matters that involve traffic related or moving violations. So today I'm here to discuss what happens when you run a red light where there's a red light camera. And this particular individual, they were very tenacious in fighting their ticket, shall I say, because it ended up in an appeal. So let's get into this. But before we do, got to don my driving gloves here. It's a little affectation of mine, so I need these to handle this case. And let's get underway. This will be the case of Fischetti versus the Village of Schaumburg. Once upon a time, there was a plaintiff by the name of Fischetti, and she sued the Village of Schaumburg. The case started out when she was driving and ran a red light. It was on January 26th of 2009, and she was driving her vehicle. Actually, the photographs of her vehicle were taken on January 19th of 2009. She received a notice of red light violation on January 26th of 2009. So on January 19th of 2009, at 2:01 and 50 seconds p.m., as she was driving, or somebody was driving, her vehicle was registered in her name, proceeded through a snowy intersection 42.2 seconds after the signal light had changed to red, and one close-up photograph of the vehicle's license plate indicated that this was her vehicle, or at least it was registered to her. So you can kind of see where this is going. I mean, the standard defense, depending on the state you're in, is, well, it wasn't me, it was the one-armed man. I wasn't driving, somebody else was driving my vehicle. Why should I have to pay this fine? Well, the court's going to get into that and address it summarily here in a bit. Essentially, that there's a prima facie evidence of a violation. All individuals appearing on the vehicle's license plate registration are legally responsible for the violation. That's what it said on the ticket notice. It said in big, bold capitals, you must either pay the applicable $100 fine or contest this civil violation notice by February 16th of 2009. Well, sure enough, Fischetti contested it. She asked for an in-person hearing on February 8th of 2009. She contested it in a letter stating, you do not have jurisdiction to issue me a citation for disobeying a traffic control signal. So a hearing officer took this into consideration, and on February 26th of 2009 issued a notice of findings. And you can well imagine what the findings were. She had to pay the $100 they found against her because, well, when you got videotape, the videotape doesn't lie. Clearly the car went through on a red light. And in my opinion, these red light camera jurisdictions are revenue gatherers. I mean, since the advent of red light cameras, it's reduced the number of side impacts, but now it's increased the number of rear-end auto collisions. So how much is really being saved here as far as people's personal safety and reducing the number of auto accidents? I haven't done a study on it. I don't know exactly what the stats are, but I have read some stats that indicate that rear-enders are far more prevalent now in those areas that have a red light camera. So anyway, Fischetti paid the fine. She paid the $100. If it were me, I would have been done by that point. But no, she was not happy with that result, none whatsoever. And so she actually looks like retained counsel to file an appeal. That's a lot of money. There was a lot more than $100 spent to handle this appeal. But she filed the appeal anyway, and it was decided on March 23rd of 2012. So a good 3 years afterward. So in any event, let's get into this here. So essentially in 2009, the defendant, Village of Schaumburg, Illinois, used automated cameras at the intersection of Meacham and Woodfield Roads to photograph cars that ran red light traffic signals. Schaumburg's traffic code provided that a car's owner was liable for the violation of a red light regardless of who was driving, unless the car was previously reported stolen. Now, a stolen car, that is a good defense because clearly you would not have been the driver on that because your vehicle was stolen. So that is a viable defense. So not all defenses fail in a red light camera situation, at least not in Illinois. I don't know about other jurisdictions, but They can't be too dissimilar. So the plaintiff, Fischetti, she was fined $100, with ultimately what she paid as the owner of the car that ran the red light. She complained to the circuit court that Schaumburg adjudicated the alleged violation through an administrative hearing process, even though the municipality had no statutory authority to utilize that method and had disregarded her statutory and constitutional rights to a trial by jury. So she said she had to have a trial by jury, and the fact that she was not afforded that opportunity violated her constitutional rights, both under the U.S. Constitution and under the Illinois Constitution. Well, the circuit court granted summary judgment on her case when she sued. After she paid the fine, she filed a lawsuit against the Village of Schaumburg, and the trial court granted summary judgment in favor of Schaumburg. They said, well, it was proper. The $100 fine was proper. The evidence clearly went against her, and the fine was appropriate. So they found that the summary judgment was granted on the grounds that Illinois laws, which authorized automatic red light cameras, also expressly provided for violations to be administratively adjudicated, and that civil penalties did not trigger constitutional and statutory rights to a jury of one's peers. Well, that didn't sit well with her, so she had to file an appeal, which is the subject of this case right here that we're going through. Okay, the first declaration that Schaumburg did not have jurisdiction to administratively adjudicate her traffic violation due to Section 1-2.12 of the Illinois Municipal Code, which provides that a municipality may administratively adjudicate local code violations, except for any offense under the Illinois Vehicle Code or similar offense that is a traffic regulation governing the movement of vehicles. So there's this larger statute code, the Illinois Motor Vehicles Code, and then there is this local municipal code that Schaumburg created to enforce red light cameras. So you have two statutes going on here. You have two codes. One is the larger state code for motor vehicles, 625 ILCS, I believe. And then you got the smaller Schaumburg code, which is a local. Well, typically what these cities and municipalities do is they incorporate a lot of the language of the state law into their own municipal codes so that they're able to get this legislation through and get it so they can set up their little speed traps, or in this case, red light camera traps, and be held constitutional. So after Fischetti and Schaumburg filed their motions for summary judgment, Fischetti filed an amended complaint which added a class action allegation to original pleading. So she's trying to really ramp this up here, and she's trying to get a whole class of people, essentially every motorist on the road in the state of Illinois, that would be part of this action, so that they would also benefit if she prevailed. Then maybe she'd get the statute overturned, and all these people maybe would even get a refund of their money that they ended up paying for these red light camera violations. Now, as you and I know, that's going to be highly unlikely, because generally, small individual versus government, guess who wins? I don't even need to say who wins. It's pretty obvious. And if you live long enough in this life, you're going to figure out that it's the government that actually wins and can tend to hurt the little guy. So that's where we're at. So the appellate court said that summary judgment is properly granted when the pleadings, affidavits, deposition transcripts, and exhibits on file are viewed in a light most favorable to the non-moving party. So when the Village of Schaumburg moved to get summary judgment, which means that there's no genuine issue of a material fact, it means that, yes, I mean, I see all the facts that you've presented, but there's no genuine issue, therefore we win. That motion is viewed in the light most favorable to the plaintiff in this case, because she wasn't the moving party on this judgment. So they like to give the benefit of the doubt. That's the legal standard in summary judgment here in Illinois, and probably a number of other jurisdictions in the United States. So the court went on to say that we're not persuaded by Fischetti's primary argument on appeal. Fischetti has simply disregarded pertinent statutes when she argues there is no authority for Schaumburg to use an administrative process in conjunction with its automated red light cameras. So what Fischetti was doing was she was saying, well, there are two statutes and they're kind of at odds with each other, because one's a local statute and the other one's a broader one, which has is more encompassing, and it applies to drivers. And she wasn't the driver. She said that they haven't been able to prove that she was a driver in any event. It's not really issued as whether she took issue that she was a driver or not. She said that they had the burden of proving that she was a driver, that ran the red light, and because they weren't able to prove that, she could not be held accountable for this ticket. Well, the court goes on to say that the vehicle code was at the heart of Schomburg's motion for summary judgment, and the court order now on appeal. Citizens cannot pick and choose which statutes apply to them. Statutes are read together and construed in a harmonious fashion. So what the court is saying is if you have two statutes that seemingly on the outset or just at a quick look that seem to be in conflict with each other, the court is going to harmonize those statutes, or they're going to read them together to make one larger understanding of what is trying to be accomplished by these rules, or these two apparent conflicting rules. So they're going to harmonize it as much as they can to make each statute agree with the other. And that way they are able to get through what they want to get through, or whatever punishment it is that they want to mete out. So the court went on to note from one of the cases, the court presumes that the legislature intended that two or more statutes which relate to the same subject are to be read harmoniously, and is in an unlikely event, however, that a general statute and specific statute on the same subject are conflicting, the specific language will control. So if there's more specific language in a smaller statute or a larger statute, they're going to use a more specific language to accomplish what they are trying to accomplish in that particular case. So this is actually a long opinion. I mean, for a red light camera, $100 fine, it was unbelievable how this plaintiff really dug her heels in and fought them every step of the way. But you know what? Sometimes you have to test the waters. You have to test the law to see if you're able to maybe overturn something that seems patently unfair. In this case, she did not prevail. So the court went on to basically shoot down every argument that she put up in her appeal. So the court went on to note that in March of 2008, Schomburg passed the local ordinance, which tracked the language of the new statute laws and established an automated traffic law enforcement system, included administrative adjudications within its geographic boundaries. Schomburg joined a number of jurisdictions that have deployed cameras and sensors to detect traffic violations without a law enforcement officer present on the scene. So there's legislation that was passed that allows for red light cameras. It allows for that. It allows for a summary adjudication without the presence of a law officer in the court. So it's going to be a video camera that essentially is the witness, and that's appropriate. That's acceptable. So the court went on to say, in our opinion, the meaning of the state and local laws is apparent and does not require further explanation. We find there was both state and municipal authorization for the administrative procedure that Schomburg applied to Fischetti, and that her reliance on Section 1-2.1-2 was misplaced. Okay, well, Fischetti next contended that she was ticketed pursuant to Section 11-306C of the Illinois Vehicle Code, and that this statute refers to drivers, meaning that Schomburg bore the burden of proving that she was the driver of the vehicle, not merely its registered owner, when the violation was recorded. Court didn't buy that argument. Court stated that Fischetti's factual premises is incorrect because she was not issued a ticket for violating Section 11-306. The exhibits attached to her complaints indicate she was cited pursuant to local ordinance. So they're saying, well, yeah, the language is similar, but you violated a local ordinance, and that's the one we're going to measure for your violation, not the larger statutory language of the Illinois Motor Vehicle Code. And furthermore, the court stated, we do not read Section 11-306 of the Illinois Motor Vehicle Code applies to drivers only. The relevant portion of 11-306 used the term drivers and vehicular traffic interchangeably. More specifically, 11-306C states that traffic control signals apply to drivers of vehicles and pedestrians. Vehicular traffic facing a steady circular red signal alone shall stop. Vehicular traffic facing a steady red arrow signal shall not enter the intersection, and vehicular traffic facing any steady red signal may cautiously enter the intersection to turn right after the driver yields the right of way. Fischetti's exclusive focus on the word drivers in Section 11-306 disregards the principle of statutory construction, that statutory terms are construed in context. So in other words, the court's saying she took it all out of context. She's trying to do a literal interpretation of it. The court wants to read the language more flexibly, obviously because it favors their outcome more than it does hers. So you got to love lawyers because they can wordsmith things and put spins on things to make what seems to be clear to be unclear. So that's kind of the nature of the practice. And you'll find judges do that all the time too, because guess what? Judges and appellate judges were lawyers, and they still maintain their bar licenses. All right, this case just runs on and on and on. Goes on to say that Illinois red light camera legislation specifically provided for ticketing the registered owner of a vehicle photographed by an automated red light camera regardless of who was driving. Section 625 ILCS 511-208.6D. The Illinois legislation also indicated notice shall be delivered to the registered owner of the vehicle within 30 days after the Secretary of State notifies the municipality or county of the identity of the owner of the vehicle. So they complied with all those rules. Well, Fischetti goes on to pull the constitutional card, and she says that she contends that some of her rights under the Illinois Constitution were violated, but the appellate court said she waived these theories of relief by failing to plead them in the circuit court. So if you don't mention all your causes of action in your trial court at the trial level, they're going to be deemed waived most of the time on appeal. So you have to put everything out, lay it all out, and let the chips fall where they may. And if they don't fall where you want them to fall, then you file your appeal and you allege every single possible theory that you can as to what you spelled out in the trial court. Anyway, the court went on to address it anyway because they're trying to avoid future litigation. So they're going to address this anyway, and then that's going to basically set the standard or the precedent, if you will, as to how future cases are going to be decided. So you better think twice before you want to do another appeal on a red light camera case. And I have not seen too many of these cases, at least not in the state of Illinois. So the court went on to state that the Constitution guarantee of due process encompasses both procedural and substantive due process. So there are differences between procedural and substantive due process. Procedural due process is about the specific procedures that have been used to deny a person's life, liberty, or property. Procedural due process protects persons from the deprivation, but not the mistaken or unjustified deprivation of life, liberty, or property. Substantive due process prevents the government from taking certain action, even if it does provide proper procedural safeguards. Well, the court found that there were neither applied. There were no violations of substantive or procedural due process. Waiver aside, I mean, the fact that they said that she waived it, they still wanted to address that. Well, Fischetti went on to argue that, okay, well, if you didn't violate my substantive or procedural due process, then you violated my right to a trial by a jury. And the court said that this is such a small fine of $100 to be imposed that there could be no deprivation of due process by the right to a trial by a jury. So she didn't have a right to a trial by a jury because it wasn't considered a criminal matter. It was considered a very small civil fine at the local level. So no jury is merited or warranted in a situation like that. The court did also note in passing, they stated, is it rational to find the owner rather than the driver? Certainly so. A camera can show reliably which cars and trucks go through red lights, but is less likely to show who was driving. That would make it easy for owners to point the finger at friends or children and essentially impossible for the city to prove otherwise. A system of photographic evidence reduces the costs of law enforcement and increases the proportion of all traffic offenses that are detected. These benefits can be achieved only if the owner is held responsible. This need not mean that the owner bears the economic loss. An owner can insist that the driver reimburse the outlay if he wants to use the car again or maintain the friendship. So the court's just saying, well, you're going to be ticketed. It's not going to show up on your record as points. It's a $100 fine. Pay it, and then you can collect the money from the person that actually did it. It's not going to be our job to try and hunt down who did it. You own the vehicle. You let the vehicle out onto the roads with whoever was driving it. So you're going to pay it, and you can get reimbursed, basically like a third-party complaint type of action if it was a civil case, where you get your money from the third party who's ultimately the responsible party. So the court didn't buy any of our arguments. She also stated that Fischetti contended that her constitutional right to equal protection was also violated because she didn't receive the presumption of innocence that would have been given to a driver stopped by a police officer for violating the same type of moving violation of a red light. So had a police officer ticketed her, it might have been a different circumstance where she could challenge it in court, cross-examine the police officer. But no, since this is a civil fine, it's not involving any points. That's how they're able to bypass the necessity for a jury, or also there's no violation of her equal protection. So the court said, we'd also like to point out this argument is based on the faulty factual premise that Fischetti was ticketed for violating 11306 rather than the separate legislation specific to red light cameras, which is once again the court relying on the municipal aspects. So what can we take from this? If you run a red light and the camera goes off, just pay the fine. Don't hire a lawyer. It's just going to cost you a lot of money and you're not going to win. You're just not going to win. So it was an interesting case for me, though, because I was surprised to see that a red light ticket case would actually go up on appeal. Amazing. But I think she wanted to make a point, and I have to admire her for making that point in the most strenuous of ways by filing an appeal and having a case actually heard by the appellate court in Illinois. So just be cognizant of red light camera areas. They are clearly marked, at least here in Illinois, so I know where they all are. I make sure I come to a stop and I count 3 seconds before I take my foot off the brake. When I stop at a red light and I'm making a turn, I'm going to make a right turn, which is legal in Illinois. You're allowed to do it. I do that 3-second count, and then I feel pretty comfortable. They used to ticket here in Illinois if you were crossed over the line. If you crossed the white line and came to a stop, that was considered a ticket. There was such an outcry of outrage by the general public, they lifted that, and all it is now is just if your vehicle continues to move. And they have video footage. It's not just still photos here in Illinois anymore. It's rolling video footage, so you can actually go and review your vehicle running the red light. I always look to the wheels. I've had clients come in and tell me they don't think that they ran the red light. I'll look it up online immediately with their ticket, and I'll look and I say, your wheels are moving. Those wheels did not come to a stop. I'll look at the little spokes in the rim. If it's a magnesium wheel, if it's a mag wheel or a rim, and I'll see if the wheel comes to a stop. If it doesn't, if it's continuing to even slightly roll, that's a red light camera violation. So just be aware out there. And that sums up this red light ticket case. There'll be more on the way, and time to take off the gloves. And I'm going to a car show. It's going to be pre-war cars over in Lake Forest today. Looks like a pleasant day today. No rain for a change. And these are going to be all pre-war vehicles, pre-World War II. So I'm looking to see some really old, rare cars. Take care, and more another time. Bye for now. Richard L. Slager signing off.